Good morning, everyone, and welcome 11 months on again to my living room for our annual service charge update. This is always a really popular session, so it's great to see once again so many of you signed up, and thank you for taking the time out of your day to join us. So first of all, I would like to introduce you to the team today. For those of you who don't know me, my name is Emma Hardman, and I'm a partner here at Anthony Collins. I lead the housing management team, which is where our service charge work sits and is delivered. I am also co-author of the NHF guide on service charges and estate rent charges. I'm joined today by three of my colleagues. I'll start off and then I'll hand over to my colleague Holly McKechnie, who is currently a trainee within our department. Holly will then pass to Penny. So many of you will have seen and met Penny before. Penny is now an associate within our team and she delivers lots of service charge work. And last but not least, we also have Nadira Khatoon, who is a solicitor within the team. So in terms of our agenda today, this is an annual update. So we assume that everyone attending has a base understanding of service charges. We're not going to go through the basics that sit behind it or the legislative requirements. What we're going to do is look at the key cases over the past year and look at how they have a day-to-day impact upon your role in relation to service charges. We're also going to be looking ahead to future changes that may happen and that we're expecting to happen in this area. And then finally, we'll finish with questions and answers. On the slides and when we are talking, you will see we have used some abbreviations just for ease of reference. So the first abbreviation we've used is the 1985 Act, which of course refers to the Landlord and Tenant Act 1985, which, as I'm sure you're aware, contains most of the key provisions regarding variable service charges. We then refer to the FTT, so the First Tier Tribunal Property Chamber. For those of you attending from Wales, you still have the LVT, so the Leasehold Valuation Tribunal. But the principles we're going to discuss today are equally applicable in Wales as they are in England. Appeals from the FTT then go to the Upper Tribunal, which we've shortened to UT. And then we do also have some cases today that have been decided in the Court of Appeal, and the slides shorten that to CA. So if you see those references, that's what that means. So we'll kick on with our case update. You'll see on each of the slides that we have put out the full case reference, and that will just allow you to go away and look at the case in full and read it if you want to after the session. We have also included some cases that, for those of you who have attended previously, you may recognise the names of. That is because those cases that we've discussed previously have been appealed and have been considered by a higher court, and there is a change in position. So some of them you may be familiar with, but there are new developments in that regard now. And what we've tried to do is focus on the cases that have most relevance for your day-to-day jobs, rather than cases that were about particulars for how the First Tier Tribunal operates. As is always the way, I think it's inevitable, whenever you do one of these update sessions, the day before or the actual day, there appears to be a case that's decided on the topic you're discussing, and this one is no different. So just yesterday, the Court of Appeal published a new decision in relation to a case, Gell versus 32 St John's Road, Eastbourne Management Company. And here the landlord was the management company, and it was made up of shareholders who were all leaseholders. Mr Gell was a shareholder who hadn't paid his service charge, and there were proceedings for that unpaid service charge. And his defence was actually dismissed, and he brought a claim alleging discrimination and saying that the service charge, his defence should not have been. So his appeal was actually dismissed by the Court of Appeal, but it's probably a useful one to bear in mind where you may have litigants in person acting who haven't provided an adequate defence to any unpaid charges. What we'll probably do on that case is provide an e-briefing rather than wait till our annual update next year to let you know more details about that case. So do look out for that. What we always like to do in these sessions is to make them as practical as possible for essentially lessons learnt from the cases. And when I looked through the first draft of these slides, essentially on every case, apart from the last one, which is about consultation and dispensation, we'd put in practice for every one of them about knowing your agreement. So to avoid repetition, we've taken that out of the slides generally. But I think if you go away with one takeaway today, it should be to know what's in your agreement. Whenever we're dealing with a service charge dispute or query, our starting point is to always ask for the tenancy or the lease that's relevant to the situation and look at the provisions within that. So it's really important to look at that and comply with any particular requirement. And what you'll see with the various cases is that applies in a variety of different contexts, whether it's about the services you're providing, about requirements that you have to meet with the demands for your service charges. Now, I appreciate, particularly for those of you that are from larger landlords and landlords that are essentially formed from a number of merged organisations, that you're going to have lots of different forms of agreements in place with different provisions. So I appreciate that that's not a small exercise, but it is really vitally important to ensure you're demanding service charges validly and charging accordingly. So we'll now kick off with the cases, and I'm going to cover the first case, which is Pimlet versus Curo Places. And this was a Court of Appeal decision that we had. And this is a case that we've talked about before and is in fact one that we acted on and represented Curo Places Limited in. So this case was all about the issue of could Curo, as the landlord, introduce new services and a corresponding charge after consultation with residents and a notice. And this is an issue we get commonly asked about how, as a landlord, you can introduce new services for tenants. Very common issue. And just as a recap behind the position, for those of you who've got secure tenancies, and I know there's quite a few local authorities joining us today, the position is far more straightforward. And that's because the Housing Act 1985 sets out a provision and a process for you to follow in terms of consultation with residents and then service of a notice and implementation of that change after the notice period has expired. The position for assured tenants, however, is different because there's no equivalent provision within the legislation. So essentially, you're going to have one of two types of provision within your agreement. The first will say that you can vary the services or any term of the agreement after consultation with residents and then a notice. So it essentially contractually mirrors what's in the 1985 Act for secure tenancies, and that's what's called a unilateral variation provision. Alternatively, you may have a provision that says you can only change the services or the terms and conditions with written agreement between yourself as landlord and with the resident. And just to clarify, when we're talking about changing a service, that's as defined in the tenancy agreement, and it may be just a general term and condition. It isn't a change in the service charge, albeit a change in the service charge may follow. So how did this apply in this? So in terms of the facts, Curo, who were a stock transfer landlord, had always provided a grounds maintenance service at their sheltered scheme that Mr. Pimlet was a tenant of, but they had not charged residents for it. Within the tenancy agreement, as I'm sure many of your tenancy agreements will have, there was space for the services to be provided to be listed. And that's what we're looking for whenever we look at service charges. Is there an obligation on the landlord to provide that particular service? And is there a corresponding obligation on the tenant or the leaseholder to pay for that service? So within Mr. Pimlet's tenancy agreement, there were some services listed, but that did not include grounds maintenance. And so Curo sought to rely on a unilateral variation provision within the agreement, which we'll look at in a moment, to introduce grounds maintenance as a service and the corresponding charge. And the clause that they relied on was this one. So it said the trust, which meant Curo, it was previously known as Summer Community Housing Trust, agrees to provide the services, and you'll see that services is has a capital letter there, if any, listed in the tenancy agreement, and for which you pay a service charge, providing that subject to consultation with tenants. And then we have two scenarios for removal of service or providing the service in a different way. But crucially, in the context of this case, at point 3, it may provide extra services if it believes this would be useful. So Curo sought to rely on this. They consulted with tenants. They deemed that it was useful to continue to provide a grounds maintenance service, but to do that formally under the tenancy agreement and receive income for that. So Mr. Pimlett challenged that position. And at the first tier tribunal, they held that Curo could not introduce grounds maintenance as a new service and could not rely on the clause we've just looked at. The upper tribunal upheld that position and agreed. And it also referred to what the parties were thinking when they entered at the commencement of the tenancy agreement. And the upper tribunal said, well, Mr. Pimlett, looking at the scheme with this communal grounds area, would expect Curo as a reasonable social landlord to provide that service. So Curo appealed to the Court of Appeal. And at the Court of Appeal, luckily for us, they overturned the previous decisions. And they held that Curo could rely on clause 2.10.1.3, which we looked at. And it said it was all about a matter of contract interpretation, and that you just looked at the natural and ordinary meaning of the words as set out in the tenancy agreement. So the tenancy agreement clearly set out a definition of services. Grounds maintenance was not part of that. And then there was a provision that allowed you to alter that. So it said that could be followed and introduced. So what does that mean for you in practice? It means when you're looking at introducing new services for tenants, you need to look at how the tenancy agreement has been completed to see what are the existing services you are obliged to provide. It also means you need to look at the particular terms of the tenancy agreement to see what options you have for changing those services. And that's going to be key. And particularly for those of you who've got a variety of tenancy agreements in operation, your approach may have to vary between residents. Now, it is just worth saying at this point, the matter's gone back to the first tier tribunal, who are now considering the case from an unfair contract terms perspective to see whether the provision was fair and therefore enforceable under the Consumer Rights Act 2015. So no doubt this is a case that we'll refer to again next year. I'm now going to hand over to Holly.
Thank you, Emma. So the first case that I'll be discussing today is the City of London and various leaseholders of Great Arthur House, which was concerned with the recoverability of costs for making good structural defects and right to buy leases. So in this case, the local authority was the freehold owner of a residential building, which contained a number of flats let on long leases, which were granted pursuant to the right to buy. It was an implied statutory obligation of those leases that the authority would keep and repair the structure and exterior of the building. So the leases required the leaseholders to pay a service charge in respect to the local authority's reasonable costs of both carrying out specified repairs, defined in the lease as repairs carried out in order to keep and repair the structure and exterior of the premises, not amounting to the making good of structural defects, and making good any structural defects of whose existence the landlord had notified the tenant. So the local authority proposed to carry out a major works programme, including works to the walls of the building which were necessary to fix the structural defect, and intended to make a service charge demand of around £72,000 per flat. So the leaseholders argued that the works were not specified repairs, as they were repairs to make good a structural defect, and that there was therefore no obligation on them to pay a service charge. The leaseholders then appealed to the first tier tribunal under Section 27A of the 1985 Act for a determination as to their service charge liability. So the first tier tribunal concluded that the construction presented by the leaseholders was correct, and made a declaration in favour of the leaseholders. The case then went to the upper tribunal, who held that the costs of repair works that had the effect of making good a structural defect were not payable by the leaseholder through the service charge. It was not of any consequence that the works also remedied deterioration that had occurred over the time the defect had existed. In this case, the upper tribunal held that the costs of making good structural defects would only be recoverable if the tenant had been put on notice of the likelihood of such works, or where the defect was first discovered a number of years into the lease. A notification to a tenant would of course include notifications by way of Section 125 notice, which, to remind you, is the offer notice that needs to be served on tenants exercising the right to buy to acquire, which must set out the proposed service charges to be recharged to the tenant over the next 5 years in accordance with Section 125 of the Housing Act 1985. So subsequently, the landlord then appealed to the Court of Appeal. So the Court of Appeal held that the upper tribunal's decision was correct and dismissed the appeal. It reached this conclusion due to the statutory background of the leases and the terms of the leases, holding that they could not be construed as having the intention of passing on the cost of the works to the leaseholders. Additionally, it was held that it was unimportant if works also remedied any deterioration which arose since the defect existed. So this case therefore emphasises in practice that service charge recovery will be limited to restrictions in the lease's terms. The distinction may be very significant for leaseholders, with the obvious current example being cladding issues, where there may not be a repair issue but a structural defect. Landlords should be sure to identify why works are required before seeking to recover costs through the service charge. And landlords should also consider whether works required amounting to structural defects have been notified to the leaseholders before seeking to recover through the service charge. So I'll now consider the case of Lambeth London Borough Council and NIWOS, which considered whether or not a landlord can recover the costs of a roof replacement works through a service charge if the replacement is not like for like. So this case considered whether Lambeth LBC could recover the costs of the roof replacement works through the service charge where the replacement works were not like for like. In this case, the leaseholder held a long lease of a flat in a building of which Lambeth LBC was the landlord. As originally constructed, there was a zinc roof over part of the property, and the landlord considered that the roof was defective and required replacement. It proposed to replace the roof with a glass reinforced plastic roof at an estimated cost of around £5,500. At the time of the application, the cost per leasehold had not been decided, but it was estimated to be around 2.5% of this sum. Under the terms of the leaseholder was required to pay a service charge for any renewal, repairs, or improvements to the roof. So the leaseholder issued proceedings in the First Tier Tribunal under Section 27A of the Landlord and Tenant Act 1985, disputing her liability for the service charges associated with the proposed roof works, as she considered them to be unreasonably expensive. There was no disagreement between the leaseholder and the freeholder that the roof was seriously defective and in need of replacement, as for the previous 2 years it had been covered with tarpaulin and held in place by sandbags. So the First Tier Tribunal did not deal with the issue as asked to determine, i.e. whether the cost of carrying out the proposed works would be reasonable. Instead, it held that the landlord could only replace the roof with a like-for-like replacement, and that the replacement of the roof with glass reinforced roof would be a breach of the covenant by the landlord, and that the landlord could only recover the costs of replacing the existing zinc roof with a new zinc roof through the service charge. So the landlord appealed to the upper tribunal, who allowed an appeal on the basis that the First Tier Tribunal had not considered the issue as asked to determine, so i.e. whether the service charges for the proposed roof works were reasonable. So the leaseholder had not sought to argue that only a like-for-like replacement was permitted, but rather that the proposed costs were too high. It held that the First Tier Tribunal had wrongly failed to engage with this issue. In addition, the First Tier Tribunal had not explained its conclusion that a replacement of the roof with a glass reinforced roof would be a breach of covenant. It also appeared to have decided that the proposed works did not amount to a renewal, repair or improvement, but had given no sufficient explanation for that conclusion. So the decision of the First Tier Tribunal was therefore set aside and readmitted back to the First Tier Tribunal for a further hearing. So in practice, this case again emphasises the importance of knowing the terms of your lease and considering whether works are repairs or improvements, and if they are improvements, does the lease allow for those improvements? A distinction is frequently drawn in the tribunal between repairs and improvements, and residents often argue that works are considered improvements rather than repairs, and this is to avoid paying them if the agreement either doesn't provide for works of improvements to be carried out and recovered by way of service charge, or if it's poorly drafted to allow for uncertainty on the issue. There's also a difference in the treatment of repairs and improvements. So with repairs, the landlord has an obligation to carry them out, whereas with improvements, the landlord has the discretion to carry them out. It's also important to consider whether the works are reasonable, especially in relation to improvement works. As you'll be aware, Section 19 of the Landlord and Tenant Act 1985 requires service charge costs to be reasonably incurred and for the works to be carried out to a reasonable standard. Reasonably incurred is a two-part test. So firstly, were the costs incurred reasonable? And secondly, was the action taken by the landlord to carry out the works reasonable, i.e. the decision to incur the cost? As part of this assessment, it is important to consider whether works are necessary, as sometimes works are carried out to make an estate look more attractive and not because they are necessary. This is especially important in relation to improvements, and landlords need to think about evidence when making a decision. So even when costs are recoverable under lease terms, it is important to ensure that you are able to justify any decision to conduct improvement works and that you're able to demonstrate that you have considered other less expensive options before proceeding. So the final case that I'll be discussing is Retirement Lease Housing Associated Limited and Sheller Up, which was concerned with the recovery of accommodation costs for a caretaker or warden through service charge provisions. This case was concerned with one sheltered housing development in Brighton and one sheltered housing development in Arundel. Both developments housed an on-site warden in an apartment belonging to the landlord, for which the landlord did not have to pay any rent. So the landlords of the supported housing developments sought to recover contributions towards the costs of providing accommodation for their resident manager or warden through service charge provisions in the lease. And the issue was whether the landlords could recover the notional rent that they could have charged if they'd been able to let out the caretaker's accommodation. Leaseholders for both these developments appealed to the First Tier Tribunal for a determination of their liability to contribute towards the notional costs associated with providing the accommodation to the wardens. So in terms of the leases, the Brighton Development Service Charge provision stated that it shall comprise all expenditure of the landlord in connection with the repair, management, maintenance and provision of the services. So this included the cost of the salary of the resident manager and the provision of accommodation for him at the property, and all other direct costs in connection with the provision of the resident manager's service. In addition, the landlord was required to determine and certify the amount by which the estimated service charge exceeded or fell short of the actual expenditure for the service charge year. And the lease for Arundel development stated that the tenants were obliged to pay a proportion of the cost of the warden's salary and the cost of the accommodation for the warden at the property, and all other costs in connection with the provision of the warden's services. In addition, the service charge was defined to mean 5% of the aggregate expenses and outgoings incurred by the landlord. The First Tier Tribunal held that the costs of the accommodation were not recoverable based on the interpretation of the leases, as no direct costs of the accommodation were incurred by the landlord. The landlord then appealed to the Upper Tribunal. So the Upper Tribunal held that the First Tier Tribunal was correct and dismissed the appeal. Both leases only allowed the landlord to recover costs incurred. More specific language would have been required to enable the landlord to recover the costs of providing accommodation for the manager or warden. So in practice, this case demonstrates how important it is to be aware of that only the costs provided for by the occupancy agreement are recoverable through a service charge. If the recovery of notional rent is intended, then it's important to set this out specifically in the lease with clear wording. References to expenditure will be insufficient to account for income forgone, as they will be interpreted as relating to the direct expenses of accommodation. So that's the end of my section, and I will now pass over to Penny with the next slide.
Thank you, Holly, and morning everyone, and thanks for attending today's service charge update and our second annual updating webinar format. Who knew that this would be the new normal? So this morning I'm going to be taking you through the next batch of service charge cases before I hand over to Nadira, who'll be continuing with the rest of the case law section. So without further ado, I'll move on to the first case, which is number 1 West India Quay Residential v East Tower, which concerns whether a leaseholder had been served with a contractually valid demand for the purpose of Section 20B of the 1985 Act. Okay, so as you'll be aware, Section 20B of the 1985 Act requires demands for service charges to be made within 18 months of costs being incurred, unless the landlord serves a notice on the leaseholder in writing under Section 20B(2) that costs have been incurred and that the leaseholder will subsequently be required under the terms of their lease to contribute to them by the payment of the service charge. So the ability to serve a notice softens the 18-month rule and enables a landlord to preserve its position by telling the leaseholder in writing that costs have been incurred and that a demand will be made later. So note that reference to relevant costs in Section 20B relates to the definition of relevant costs set out in Section 18 of the 1985 Act, which provides that the relevant costs are the costs in connection with the matters for which the service charge is payable. So this means that a Section 20B notice must set out the total costs which have been incurred by the landlord but not yet demanded, and not a leaseholder's individual contribution to those costs. And in order to be a demand for service charges in accordance with Section 20B, Section 20B(1), established case law provides that demand must be a contractually valid demand which complies with the requirements of the particular lease. So number 1, West India Quay was the owner of a large mixed-use development with a hotel and residential flats above. The flats were let on long leases and East Tower held around 30 flats. Under the terms of the leases, the landlord was entitled to recover the costs of providing electricity and other utilities. It was also entitled under a separate covenant to recover its costs incurred in providing services to the building by way of service charge. At this scheme, the utility metering was complex, and the landlords had retained a specialist contractor to retain the meters, to allocate costs between the various parts of the development, and also to produce individual bills to be recharged to each leaseholder. Between 2008 and 2012, it charged the cost of those contractors as a surcharge on the electricity costs. The leaseholders applied to the first tier tribunal for a determination of payability and reasonableness of various service charges, including the surcharge levied on utilities under Section 27A of the 1985 Act. The FTT upheld the practice of charging the leaseholders the cost of the contractors as a surcharge on utility costs, finding that the surcharges demanded from the leaseholders were due for payment. The leaseholders appealed to the upper tribunal. So the upper tribunal held that the surcharge was not a charge for the provision of utilities, but a service charge that had not yet been demanded in accordance with the specific service charge provisions in the lease, which would include a requirement for the surcharges to be included in the end-of-year service charge reconciliation. During the hearing, the parties also raised issues around whether the surcharges had been demanded in accordance with Section 20B of the 1985 Act, but the upper tribunal was not prepared to determine any issue concerning Section 20, as it considered that the appeal was a review of the FTT decision and not a rehearing of the application made under Section 27A. So the upper tribunal remitted the matter to the FTT to determine compliance with Section 20B. The FTT held that the surcharges were not payable by the leaseholders, as the demands for the charges did not comply with the service charge provisions in the lease. So this meant that there had been no valid demand for the charges for the purpose of Section 20B(1) of the Act, which is the requirement to demand service charges within 18 months of incurring the cost. And as mentioned earlier, established case law provides that in order to be a demand for service charges in accordance with Section 20B(1), the demand must be a contractually valid demand, which complies with the specific requirements of the lease. The landlord appealed to the upper tribunal. So the upper tribunal agreed with the FTT, finding that the service charges had not been demanded in accordance with Section 20B(1) and were not lawfully due for payment by the leaseholders. This was because, although the original demand had been made within 18 months of incurring the costs, it was not a demand which complied with the service charge provisions in the lease. So this case reaffirmed the established position that only the presentation of a contractually valid demand would stop time running against the recovery of a service charge under Section 20B(1). The upper tribunal also considered whether the original demand served on leaseholders could operate as a notice for the purpose of Section 20B(2), and was therefore enough to stop time running against the landlord's claim. However, as the original demand had only set out the leaseholder's individual contribution to the surcharges, and also no reference had been made to the total undemanded costs incurred for which the service charge was payable, and a statement that the costs had been incurred and that the leaseholder would be required to contribute to them by the payment of a service charge later, as required by Section 20B(2), it was held that the demand was not a notice for the purpose of Section 20B(2) of the 1985 Act. So in practice, this case highlights the importance of ensuring that service charges are demanded in accordance with both Section 20B and the provisions of your occupancy agreements. It's important to ensure that you have clear processes in place to ensure that within 18 months of incurring service charge costs, that those costs are either demanded by way of a contractually valid demand, or that a notice is served which fully complies with the requirements of Section 20B(2). Okay, the next case I want to talk about is Aviva v Williams, which concerns the apportionment of service charge costs, the interpretation of leases, and Section 27A(6) of the 1985 Act. And you may recall we dealt with the decision of the upper tribunal in this matter at our service charge update last year. So Section 27A(6) is set out for you on the next slide, which I will allow you to digest for a few moments. So this was an appeal by the leaseholders of 39 flats against the FTT's decision about the reasonableness and payability of service charges. The appeal turned on the construction of the apportionment clause in the lease, which stated that the leaseholder would pay 0.7135% of the building services costs or such other part as the landlord may otherwise reasonably determine. There were also similar clauses in respect of insurance costs and estate services. Aviva had been demanding service charges in different proportions from the percentage amount set out in the lease. The leaseholders applied to the FTT for a determination on the reasonableness and payability of service charges, and the FTT found for Aviva and that the sums were reasonable and payable by the leaseholders. In the upper tribunal, the leaseholders argued that Section 27A6 rendered void the words "or such other part as the landlord may otherwise reasonably determine" in the lease. The decision of the FTT was set aside, and the words "or such other part as the landlord may otherwise reasonably determine" were judged to be void, and the landlord was only able to recover the percentage apportionments set out in the lease. And it was held that any changes to this amount would have to be done by varying the leases with the tenant's agreement or by an application to the tribunal. The landlord appealed to the Court of Appeal. So the Court of Appeal allowed an appeal, finding that Section 27A6 did not void the clause. All it did was remove the landlord's role from the decision-making process in the event that a different percentage could not be agreed, and transferred it to the FTT. So accordingly, the lease should be read as if it had provided for the fixed percentage or such other part as may reasonably be determined. The decision of the FTT was restored and the sums were payable by the leaseholder. So this decision will be welcomed by landlords, as leases on developments commonly include this wording to in particular allow for different apportionments of service charges as schemes develop and change. So in practice, consider apportionment provisions of new leases and calculation of charges under existing leases. And where there is a set percentage or mechanism for apportionment in leases, that mechanism must be used to calculate the service charges payable. This case, however, makes it clear that whilst the wording was not void, as the upper tribunal had held, the decision does not allow landlords to unilaterally vary the apportionment mechanism under the leases under Section 27A(1). So even if the lease does contain wording allowing the mechanism to be changed by the landlord, this case means that the task of making that determination is transferred from the landlord to the FTT, meaning that it was open to the landlord or the tenant to refer the question of a different percentage to the FTT for determination, and that this was not excluded from the FTT's jurisdiction, as the upper tribunal had wrongly decided. So the next case in this section is H. Stein v Richmond, which concerns whether a wrong payment date set out in a service charge demand invalidated that demand. So H. Stein Limited was the landlord of a residential flat on the second floor of a block of flats in London. Miss Richmond was the leaseholder. The lease required the leaseholder to pay on demand a due proportion of the repair and maintenance costs incurred or anticipated to be incurred by the landlord, provided that not less than 1 month's notice of any advance payment or contribution was given to the tenant. The landlord's managing agent served a demand for advance service charges on the leaseholder by post in August 2015, and this referred to the amount owed of £2,255.77 and stated payment due 30 days after date of demand, arrears by return. The leaseholder did not pay the advance sums demanded by the landlord, so the landlord issued debt recovery proceedings in the county court for unpaid service charges. The county court then transferred the matter to the FTT for a determination on reasonableness and payability. The FTT held that the demand was invalid because less than 1 month's notice had been given in the demand, and therefore that the service charge was not payable by the leaseholder. The landlord appealed to the upper tribunal, arguing that on a reasonable interpretation of the demands, the leaseholder would understand that they had a full month's time to pay the sum. The upper tribunal dismissed the appeal, finding that the FTT had reached the correct conclusion and that it didn't matter whether a reasonable recipient would have understood the intention of the demand. It held that a 1 month's notice requirement was an essential prerequisite in order for there to be a valid demand for service charges in accordance with the lease, finding that the demand needed to specify the correct payment due date so that the parties knew when the obligation had to be performed. As only 29 days' notice had been given in the demand by the landlord, and the notice condition had not therefore been satisfied, the demand was invalid and the leaseholder had no liability to pay the service charges at the time the proceedings in the court were issued. So this case again highlights the importance of ensuring the prerequisites for service charge demands are met. The wording and purpose of any notice provisions should be used to identify the essential prerequisites so you can ensure that they're satisfied. Minor errors, as in this case, can be fatal to the validity of service charges when it comes down to the specific wording of the lease. And clear, unambiguous lease drafting, which leaves no doubt as to the requirements to be satisfied before a demand will trigger liability, including any notice provisions, will help to avoid similar disputes. So the final case in this section is Price v Matty, which concerns whether a wrong proportion invalidates a service charge demand. Miss Price was the leaseholder of a flat in a building of which various members of the Matty family were the landlords. It was a term of Miss Price's lease that she had to pay 1/31 of the costs incurred by the landlords in providing services. So rather than demanding 1/31 from Miss Price, the landlords instead demanded 1/24 of all its expenditure. Miss Price considered that the demands were invalid because they were not for the proportion specified in the lease, so that the landlords made an application to the FTT for a determination on the payability and reasonableness of service charges for the period 2009 to 2017. So the FTT rejected Miss Price's argument that the demands were invalid and held that the correct approach was to limit the demands to the figure that would be due if only 1/31 of the costs were charged. The leaseholder appealed to the upper tribunal. The upper tribunal dismissed an appeal, finding that demand for too high a sum did not mean that the demand was invalid. In this case, the demands did not refer to the incorrect proportion, only to the sum due, which was in the wrong amount based on the proportion in the lease. It was only the service charge budget that had identified the incorrect proportion, and the demand itself was held to be formally valid, acknowledging that the FTT then had jurisdiction under Section 27A of the 1985 Act to determine what was payable, namely the correct proportion of 1/31 of the costs. The correct approach was for the FTT to treat the demand as relating to the lower sum that would have been due if only 1/31 were charged. So in practice, this case highlights that calculation errors are not always sufficient to completely invalidate service charge demands, although recovery will be limited to the proportion set out in the occupancy agreement. And to help avoid similar disputes, where there is a set percentage or mechanism for apportionment of service charges in occupancy agreements, that mechanism must be used to calculate the service charge payable, which should then be correctly reflected in the service charge demands served on residents. So this is the end of my case law update. I'll now pass over to Nadira, who will be taking you through the last batch of cases. Thanks for listening.
Thank you, Penny, and hello everyone. The first case I'll be covering is the Upper Tribunal case of Powell & Co Investments Limited versus Elsa Alexandrova and Dr. Mario Alexander. The issue in question was a service charge demand valid if the contractual requirements of the lease had not been satisfied? So last year, the leaseholders applied to the first tier tribunal for a determination of their liability to pay the service charge billed by the landlord for the year ending June 2019. The lease contained a conventional service charge clause whereby the leaseholders covenanted to pay 18% of the landlord's annual costs, expenses and outgoings. You will find on your screen an extract from the lease relating to the leaseholder's obligation to meet any shortfall on account after payment of their percentage. So the provision here states such payment would be payable upon production of a certified account. A further provision in the lease states that certification must be by a chartered accountant to be appointed by the landlord. Now, the 2019 accounts were instead certified by the landlord's managing agent, but included a factual report by a firm of accountants. The only certificate was from the managing agent, which stated that the agent was responsible for the production of the service charge certificates for that year, and they purported to confirm that the certificate was produced in compliance with the lease. The first tier tribunal held that there was no sum yet payable by the leaseholder as the accounts had not been certified by a chartered accountant as required by the lease. The landlord appealed. The upper tribunal, when looking at the matter, stated the lease does not require that the annual service charge accounts themselves specifically be certified, but that the amount of the leaseholder's liability be certified. So this would require consideration of the leaseholder's 18% share of the total expenditure, their payments made on account, and the resulting shortfall surplus from this. The resulting shortfall and surplus is what should be certified. So it followed that the first-year tribunal statement that there is an obligation under the terms of the lease for the accounts themselves to be certified by a chartered accountant was not strictly accurate. So what was required is that the individual leaseholder's liability of payment of the shortfall be certified by a chartered accountant. The tribunal did accept that unless it is a requirement of the lease, then generally certification of service charge accounts by an accountant need not be undertaken. However, under this lease, it is a requirement. The tribunal determined that the accounts produced did not include a certificate as required under the lease, and until this was satisfied, the leaseholder would not be liable to pay the demanded amount. So what does this mean in practice? You should ensure specific conditions set out for service charge demands are met. Care needs to be taken to ensure that any certificate or statement follows the exact terminology used in the lease. So if your lease states accounts or certificates must be certified by a chartered accountant or another specific body, then this must be followed. You should ensure that you check the lease definition as to who or what constitutes this specific body. If these conditions aren't met, the leaseholder will not be obliged to pay until this is satisfied. Just to reiterate Penny's point made earlier, as a landlord, you have 18 months within which to notify leaseholders of service charge costs being incurred or demand payment from them. If you fail to either notify or demand payment within this 18 months, you will not be able to recover the charges from them. The next case I'll be covering is the Upper Tribunal case of Ken Square Limited and Adoa and Anor. The issue in question was whether time is of the essence when it came to giving notice of interim payment. This was actually the second set of proceedings before the first-year tribunal. In 2017, the landlord applied for a determination of the reasonableness and payability of interim service charges for the years 2011 to 2017, and it was held payable. The leaseholders did not actually pay the amount, and the landlord served a Section 146 notice. As you'll be aware, this is a notice of forfeiture of the lease due to a breach of covenant. In this case, the leaseholder's mortgagee actually paid off the whole amount. In the present case, an application was made for the determination of interim service charges in respect of the years 2018 to 19 and 2019 to 20. The landlord had sent a service charge demand in August 2019 for interim payments for these periods. This all came to approximately around £6,000. Also, the first-year tribunal was asked to determine the leaseholder's liability to pay legal costs as an administration charge as per a provision in the lease. The first-year tribunal held that the lease sets out provisions for interim payments to be made on the 1st of April and 1st of October for a total of £360 annually. They stated that if there is to be any revised amount, then no less than 1 month's notice is to be given prior to the commencement of that financial year. In this case, service charge demands had been made for the interim payments. However, no notice satisfying this timescale as per the lease provision had been given. The first-year tribunal held that in the absence of any evidence that notice had been served within the timeframe specifically, then no notice had been served. Therefore, the revised amount of approximately £6,000 was not payable. So the first-year tribunal also held that the legal costs, which under the lease provision might be recoverable as an administration charge, were limited to the costs incurred in preparing and serving a Section 146 notice in 2017 and did not include the costs the landlord incurred for the 2017 proceedings. The leaseholders were also not liable to pay the legal costs for the current proceedings nor the 2017 proceedings by way of a service charge as per the terms of the lease. Also, in this case, a matter of issue estoppel arose. As a reminder, estoppel in this instance has the meaning of when a particular issue has already been decided in a first action or hearing and is therefore barred to be reconsidered in subsequent proceedings between the same parties to which the same issue is relevant. The landlord argued that the first-year tribunal in 2017 had already made a decision that the interim service charges were payable for the full amount, which was in excess of £360. The first-tier tribunal in the present case should not have diverted from the previous decision. The first-tier tribunal actually agreed, but found that exceptional circumstances justified it in overriding that estoppel. The landlord appealed. They sought the full amount of service charges demanded for 2018 to 2020, the full amount of the charges claimed under the fourth schedule of the lease. This required leaseholders to pay all costs, charges, expenses. This included solicitors' costs and surveyors' fees incurred by the lessor for the purpose of or incidental to the preparation and service of a notice under Section 146 of the Law of Property Act 1925. They also sought costs of both sets of tribunal proceedings by way of service charge under the lease. The upper tribunal considered these points and they stated the following. So on the matter of estoppel, they stated that as their conclusion is actually consistent with the decision reached by the 2017 first-tier tribunal, the estoppel point is irrelevant. They continue to say that even if their conclusion was not consistent with the decision, they would still not have agreed with the first-tier tribunal's decision to override due to exceptional circumstances. There was no actual basis for the first-tier tribunal's decision that interim service charge amounts were not payable as demanded. They held that the provisions in the lease made it clear that on the 1st of April and October of each year, the tenant is to pay an interim service charge of £360 per annum. This can be revised in future years after the first year. The lease contained a provision setting out the procedure to revise the service charges. Naturally, if the tenant hears nothing, they will carry on paying the £360 per annum. If the landlord expected this wouldn't be sufficient, they may calculate the appropriate contribution and give notice of the revised amount no less than 1 month prior to the commencement of that financial year. They held that demands served by the landlord for the 2018 to 19 and 2019 to 2020 interim service charge accounts were valid, regardless of whether notice had been given of the revised amount as per the lease. They stated that the interim service charge clause should not have been construed in a way to make it as if time was of the essence. For time to be of the essence, very clear wording would be required. They also stated that the landlord's legal costs incurred in 2017 was recoverable under the fourth schedule, and costs for present proceedings were also recoverable, as both were incurred in connection with the management of the building and were therefore recoverable as part of the service charge. So what does this mean in practice? You should be aware that interim charges for retrospective periods are payable even when these provisions require a notice period is satisfied, so time will not be of the essence. For time to be of the essence, a very clear wording would be required. It must be an express provision. The final case I'll be covering is a Court of Appeal case of Astor Communities v. Chapman. This is a high-profile case, and you may have actually come across it in Inside Housing last week. This case considers dispensation from consultation requirements and the conditions attached to such dispensations. The landlord owned a number of flats on long leases. They carried out various works and in 2017 sought to recover cost of the work from the leaseholders through service charge. An application was made to the first-tier tribunal for a determination of this service charge. When looking into the service charge issue, the tribunal had to consider Section 20 consultation requirements. As a reminder, the leading case is that of the Supreme Court's decision in Dejan Investments Limited. There it was held, in order to oppose an application for dispensation, the leaseholders must have suffered a relevant prejudice. They must prove they would have acted differently had the landlord carried out consultation accordingly. In this case, the landlord had actually carried out pre-works consultation. However, they had not included certain specific works. The first-tier tribunal held costs of such works could not be passed through the service charge. The landlord applied for dispensation from the consultation requirements so it could try and include the costs of these works in the service charge. The first-tier tribunal applied the test from Dejan Investments. They held that if the landlord had actually complied with the consultation requirements, then one of the leaseholders would have acted differently. She would have obtained a surveyor's report. Therefore, relevant prejudice was established. However, they did still grant dispensation on the condition that the landlord paid the leaseholders reasonable costs for obtaining expert evidence and that of the application. These costs could not be recovered through service charge. The landlord appealed. The upper tribunal actually dismissed their appeal. However, the Court of Appeal allowed this. The landlord raised 3 points. The first was that the first-tier tribunal was wrong to conclude that the leaseholder would have acted differently if consultation requirements had been complied. The second was the issue of relevant prejudice should be separately assessed for each leaseholder. And finally, they argued that it was impermissible for the first-tier tribunal to impose conditions that the landlord pay the leaseholder's reasonable costs of an expert report and that of the application. The Court of Appeal dismissed all 3 grounds. They stated, all leaseholders suffered the same prejudice and are all entitled to the benefit of the same condition. The consultation is a group process. A landlord seeks dispensation against tenants generally and not individually. The first-tier tribunal was also entitled to impose on the landlord a condition to pay for an expert report. The condition to pay the leaseholder's costs of the application was similar to the condition imposed in Dejan Investments. So in practice, you should ideally ensure that Section 20 requirements are complied with, and if pre-work consultation has taken place, not to divert from the specific works discussed and noted during the consultation process. If you do apply for dispensation, please be aware that there is a potential for conditions to be attached to the dispensation being granted, including payment of leaseholders' various costs. That's all from me. I will now hand back over to Emma.
So we're going to shift our focus from what's happened in the past year to moving forward and looking ahead for some changes that we are expecting to see and that will affect really additional work that you'll have to deliver within your organisations in respect of costs. So some of you may have attended our housing management update in autumn, and we talked about those then. That session generally isn't about service charges, but these were things we mentioned. So the first thing to say is that for a number of years, the government has considered and announced various changes that will be happening in respect of leasehold reform, which may of course impact upon service delivery and service charges delivery within your organisation. So the first thing to mention is that for tenants who will be occupying affordable homes developed and funded through the new Affordable Homes Programme for 2021 to 2026, there will be a new right of shared ownership. We have seen some initial guidance on this, but the more detailed guidance will be published in due course. I suspect possibly at the same time the new model lease will be published, which was expected to be May. So we await details there. And many of you will have seen that under that new model lease, residents will be able to purchase an initial 10% share in the property and then do staircasing increments of 1% rather than the 25% they have done currently. There's also big changes proposed in respect of ground rents, and this is something we've mentioned a few times before. And this is very much really in response to the ground rent scandal, more in the private sector, where the Consumer Markets Authority has looked at this issue and considered unfair provisions. So as a result of those investigations, the government has announced that generally no houses should now be sold on a leasehold basis. They should be sold on a freehold basis. Rents should be limited to peppercorn rents. And this is reflected in the Leasehold Reform Ground Rent Bill that was published a couple of weeks ago following the Queen's speech, and it was part of that. So under that draft bill, which is still to be finalised, there are various exceptions. And those exceptions include shared ownership leases. As you would expect, obviously they will be paying on rent on the proportion that they don't own. And where there is a community land trust that is the freeholder to protect that setup there. So that's something that we'll see come into force in the next year. One of the other changes announced is that there'll be a set process and tighter timescales for sale of leasehold interest. And this should help in respect of service charges in terms of a better flow and transparency of information. So essentially, incoming leaseholders will have a much clearer understanding of what their potential service charge liability is and what that means for them in practice, and that there'll be tight timescales on you as a landlord to provide that information. And then the other key change, which again we've mentioned previously, but that has been confirmed, is that the rights and obligations that we see in respect of variable service charge payers will be extended to those who pay freehold charges, estate rent charges. However, that proposal wasn't included in the Queen's Speech, and therefore we're not clear on the timescales involved in that. But it's worth planning ahead, knowing that where you have stock that has been sold on a freehold basis and residents are paying charges there, that you're going to have to adapt and extend your service charge team to those residents. So thinking ahead for that planning. What was included in the Queen's Speech, however, was the Building Safety Bill, which has already been working its way through Parliament, but the government announced via the Queen's Speech that they'd be looking to introduce in this parliamentary session. And the bill introduces a raft of changes in respect of building safety, obviously mainly post-Grenfell, and sits along the changes that have recently been introduced in the Fire Safety Act. So one of the elements of the bill is a new charge for leaseholders, and this will be called the Building Safety Charge. And it sits outside the variable service charge. So you'll have your variable service charge payable under a lease if your lease provides for that. And then you'll also have a building safety charge. Now, under the bill, it is just draft legislation at the moment, so these are proposals. We await for the bill to be finalised, and then we also await publication of the regulations that will be passed under that bill that will contain more of the detail. So building safety charges will essentially be the charges that the accountable person, so the person under the bill who has responsibility for the safety of the building, for their costs incurred or estimated to be incurred for delivering the works that will be required under the Act when it comes into force. And it will only apply in relation to higher risk buildings. So we await to see what those buildings, the exact definition of those. But at the moment, it's anticipated to include buildings over 18 metres high, those over 6 stories high, and also student accommodation. So if any of your existing buildings meet that current expected definition, it's worth planning ahead to ensure you are building safety bill ready. It also applies where there are long leases only, so any leases over 21 years, but that will be defined to include shared ownership lease. And having said right at the beginning that you always need to look at the lease, actually this is one case where the legislation, when it comes into force, will imply rights, so imply provisions in the lease that sit on top of the lease and override what's in it. So this will be twofold. There'll be, first of all, a right of access for the landlord to go into the property and deliver the works required. And also, crucially, from your perspective, a obligation on the leaseholder to pay the charges for those works. So in some respects, there are a lot of similarities between the building safety charges and the variable service charge regime. So the first thing is that the works and the costs themselves must be reasonable. So reasonable in terms of the quality of the work delivered and also the costs undertaken. There will also be consultation requirements. So similar to the Section 20 consultation requirements now, but a new Section 17K, I think it is, consultation process. Because what the bill anticipates is that it will insert a whole new raft of sections within the 1985 Act. So there will be consultation where there's a qualifying long-term agreement or where there's qualifying works. But the detail of that will be set out in regulations. And I really hope there that the government use this as an opportunity to perhaps have a refresh of the thresholds, so the amounts in which those circumstances are triggered, and also ideally to tackle the tricky issue of existing framework agreements and that not sitting neatly with Section 20 consultation obligation. Interestingly, there is a proposal for exception here. So currently, if works were undertaken that were urgent, that needed Section 20 consultation, but you didn't have time to carry that out, a landlord would have to apply for dispensation from the first tier tribunal if it wanted to recover the cost of those works in full. However, what's proposed here is that for urgent works, there will be an exemption, and a landlord will be able to claim that exemption by completing a prescribed certificate. So that's going to be interesting to see how that works. There'll still be the 18-month rule, which Penny had explained earlier in terms of charging costs within the 18 months. But a landlord will be able to raise the costs every 3 months, and the leaseholder will have to pay within 28 days of that demand. With each demand, there'll be an obligation to serve a summary of tenants' rights and obligations. I suspect that will be a different prescribed form to the one you currently use for variable service charges reflecting the different elements in the regime that we've. So what are the differences? I think most crucially for landlords, and the bit that's possibly going to cause most difficulty from a practical perspective, is that the bill anticipates reconciliation of costs within 28 days. So reconciliation between estimated and actual costs within 28 days. Currently, landlords would do that within a period of 6 months, so a much tighter time frame. There'll also be obligations of cooperation where there's various parties involved in the scheme. So, for example, where you've got managing agents and management companies and various intermediate landlords. And also there'll be a duty to apply for available funding. So if funding was available from the government to assist with the costs, a landlord would have to apply for that. And that would therefore prevent payment of service charge for those costs where funding was available. So this is definitely one to watch and start to think about. We've developed a product here at Anthony Collins called the Building Safety Workbook, and this is designed to be a practical tool that asks organisations questions and helps them work through the bill and the various aspects that they need to start thinking about and planning for, which does include service charges. Please do contact us if you think that product would be of interest to your organisation. Okay, we'll now open the floor for questions. I think I'll direct one of the questions to you first of all, Penny, if that's okay. So the first question is from Carla. So Carla has asked, if a demand was issued but did not include the certificate from a chartered accountant, I think this links to the case Nadira discussed, would the demand date still be valid, or would the demand date then apply from when the certificate was submitted? Do you want to share your thoughts on that?
Yeah, so again, I think it's going to come down to the specific wording of your leases, and whether there's a nexus really between the provision of a demand and providing the certificate. So for example, if a lease provides that for a certificate and the leaseholder will then demand service charges on receipt of that certificate, then it's likely that the service charges won't fall due until the certificate is provided. But if there's no nexus between the certificate and the demand, then it's likely that the service charge would be due. So really it depends on the wording of the lease.
Thank you, Penny. Scott's asked a question about the building safety charge. Is this going to be levied at all tenants or just long leaseholders and share owners? So no, this will just be at long leaseholders, so those who have leases over 21 years. And that reflects really that the work is going to be undertaken in accordance with the Act are really going to link to the structure and exterior of the property, and therefore for tenants that's covered by a landlord's obligations under Section 11 of the 1985 Act. They wouldn't be charged to tenants through the service charge. So Veronica's asked, following on from the City of London versus leaseholders of Great Arthur House to some extent, we have a shared boundary brick wall with shared liability. The wall needs rebuilding in part due to movement. The neighbouring property consists of 3 private leaseholders. What guidance can you give on how to recover the costs of the work from the private leaseholders? I think the first thing to say there, Veronica, would be to check under what provisions under the lease that charge is made, because it might not be through the service charge necessarily. It could just be a contractual obligation to contribute to that cost. So I think you need to just consider under what provision they're paying for that, because it could be via enforcement of a contractual obligation and debt proceedings rather than necessarily a service charge. I hope that answers that. Got a question here. If a tenancy stipulates a variable service charge but has incorrectly been charged as a fixed, is a landlord able to switch the service charge over to a variable, and what form of consultation would be required, and how much notice should be given in advance of the change? So there, Rob, a change from a variable to a fixed service charge, or indeed vice versa, is a change in the terms and conditions of the tenancy agreement rather than a change in the service charge amount. So again, you'd be looking at the provisions within the agreement about how you change the terms and conditions. So those provisions that I mentioned earlier when I was talking about the Pimlet and Curo case, looking at what provisions you've got in the agreement. What I would say there, however, is where a tenancy term and condition allows you to change any term and condition within the tenancy, That's what we call a wide unilateral variation clause. And there is some questions about whether that clause is fair and therefore enforceable. So if the clause is just about changing services, then that's narrower in its remit, so it's probably more likely to be fair. But if it's wide, then there were some comments in a Peabody case, Peabody versus Reeve a number of years ago, which raised questions about that. So what I would say is, if you're going to look at doing that change, you're best to get advice about looking at the type of provisions you've got in the agreement and then analysing the different risks involved in following those procedures as to whether it would be fair or not. But consultation would inevitably be required, and that would need to be very transparent consultation about what rights residents would gain and would lose through the different type of service charge. I hope that answers that question. So Claire's asked a question, with regards to consultation, planned maintenance team have bought materials in 2020-21, but haven't yet consulted with residents on electrical work. Would this be recoverable, or can we now only recover costs incurred post-consultation? Penny, do you want to take that one?
Yes. So sorry, when were the costs incurred?
So planned maintenance team have bought materials in 2020-21, but haven't yet consulted with residents on the electrical works. Would we be able to recover, or can we now only recover costs incurred post-consultation?
Okay. So the first thing is to preserve your position in relation to the recovery of those costs if you haven't yet consulted. So you'd serve your section 20B2 notice if there is still time to do that, and then you would then carry out your consultation, conclude consultation, and then because you've preserved your position by serving your section 20B notice, you would then be able to recover those costs.
Thank you, Penny. So I think we've got time for one more. A question here, the change to leasehold houses, is that just new house sales to be freehold, or does it mean existing leasehold houses must change to freehold for sale? No, that is just new ones moving forward. It won't generally apply retrospectively, apart from the date when the government made the announcement that the change would be happening, which was last year. So I'll just confirm the exact date afterwards to Pam. So from the point the government made the announcement, there shouldn't have been any more granted at that point, but retrospectively it won't change. And that's just recognising the fact, obviously, that schemes will have been set up in that way. What I would, however, say is, alongside that, the government are also pushing for and have announced that there'll be changes to the right of extension for leases and acquiring freeholds to make that process easier. So that could be an option that those residents look to enforce. Okay, thank you so much for all the questions. As I say, if we haven't been able to come back to you, we will do so directly afterwards. Thank you very much for your time today, and hope to actually see you in real life soon. Thank you.